We have thus completed all the statutory provisions relating to grant of bail in case of non-bailable offences. We have seen that every non-bailable offence is in fact bailable. The name non-bailable is a big misnomer and is highly misleading. Bail can be given in every non-bailable offence, and it can be given not only by the court of magistrate but also by the police officer in charge of the police station. The difference between a bailable offence and a non-bailable offence lies in the fact that whereas in case of a bailable offence, the accused is entitled to be released on bail, in case of non-bailable offence, it is the discretion of the police officer or the court, and it is not a right given to the accused. The general norm is that the accused shall be released on bail in every case of non-bailable offence, but then there are two exceptions to this general rule. The first exception is that the court or the police officer shall not release the accused on bail if he is accused of an offence which is punishable with death or life imprisonment. This is the first exception to the general norm set in section 437. But this exception also has one exception, which means there is a situation where bail can be given to an accused who is suspected of an offence punishable with death or life imprisonment also. And that situation is where the accused is a woman, where the accused is a male below 16 years of age, where the accused is sick, where the accused is infirm. In all these four situations, the accused can be released on bail even when he is suspected of having committed an offence which is punishable with death or life imprisonment. So this is the exception to section 437(1). Then there is second exception to section 437(1). Bail shall not be granted to a person who was previously convicted of an offence which was punishable with imprisonment of up to 7 years, or where he was previously convicted more than once with offences punishable with 3 years or more, and in total not less than 7 years. We can term this exception as the exception applicable to a person who was previously convicted. This is the second exception. But even to this exception, there are two exceptions, which means even a person who was earlier convicted and who is now accused of having committed a non-bailable offence can be released on bail in two situations. Firstly, if the accused is a woman, a male below 16 years, infirm and sick, then he can be released even if he had earlier convicted of an offence. And secondly, a repeat offender can be released when the court thinks there are special reasons for so doing. What are those special reasons? That is not elaborated. The statutory provision merely mentions that there must be special reasons. One more thing that needs to be noted is that the exceptions to exceptions, as we call them, can be used only by the court, not by the police officer. So, as a rule, a police officer cannot release an accused on bail if he is suspected of having committed an offence which is punishable with death or life imprisonment, and he also cannot release an accused who had been previously convicted of the offences specified in the section. As far as the police officer is concerned, that's the end of it. But exceptions to exceptions are applicable to a court, the magistrate can grant bail even in these cases. Now, summing up, we can say that the bail is available in case of every non-bailable offense, but only on the discretion of the police officer or the court. Therefore, the next important question is, in what way is this discretion to be exercised? What are the guidelines for exercising the discretion? The Act is silent, but we have authoritative pronouncements from the Supreme Court which will guide us as to in what way this discretion which is given to the police officer as well as to the court is to be exercised. For the purpose, we will go through a judgment of the Supreme Court rendered in 1978 in Gurcharan Singh versus Delhi Administration. The court has observed in this case that subsection 1 of section 437 makes a dichotomy in dealing with non-bailable offences. A dichotomy means a sharp division in two. So as far as non-bailable offences are concerned, section 437(1) makes a dichotomy. It divides them in two parts. The first category relates to offences which are punishable with death or life imprisonment, and the second category comprises of all other non-bailable offences. So these are the two categories. With regard to the first category, section 437(1) imposes a bar to grant of bail to a person who is accused or suspected of an offence which is punishable with death or life imprisonment if there appear reasonable grounds for believing that he has been so guilty. There must be reasonable grounds for believing that the accused is guilty of such an offence. In all other non-bailable cases, that is the second category, judicial discretion will always be exercised by the court in favor of granting bail. This is an important statement of law. Judicial discretion in every other non-bailable offence will always be exercised by the court in favor of granting bail, subject of course to section 437(3), which lays down certain conditions for release. The principle underlying section 437 is therefore towards granting of bail, except in cases where there appear to be reasonable grounds for believing that the accused has been guilty of an offence punishable with death or life imprisonment, and also when there are other valid reasons to justify the refusal of bail. Unless exceptional circumstances are brought to the notice of the court, which may defeat proper investigation and a fair trial, the court will not decline to grant bail to a person who is not accused of an offence which is punishable with death or imprisonment for life. Apart from this exception, the court shall not refuse to grant bail. Exceptional circumstances must be there if bail is to be declined. And what kind of exceptional circumstances? Those circumstances which will defeat proper investigation or a fair trial. So the overriding considerations in refusing bail are these two, the two paramount considerations. What are the two paramount considerations when bail can be refused? Number one, if there is likelihood of the accused fleeing from justice. If there is likelihood of the accused fleeing from justice, bail can be refused under section 437(1). Secondly, if there is likelihood of the accused tampering with prosecution evidence, then also bail can be refused under section 437(1).